Whether for the AP US History test or simply to understand history better, the Dred Scott decision is a fascinating Supreme Court decision, but not for the reasons you might think. It was not brilliant. In fact, it diminished the stature of the Supreme Court as an institution for over 50 years and is considered the worst opinion in its history. This graphic behind me communicates well what a stinker of a case this was. It had little value in shaping our laws because it was overturned by the 13th Amendment a few years after it was issued. The Dred Scott decision is fascinating because it was a major step in plunging this nation into a costly and bloody civil war where 630,000 lives were lost. It also shows us how far we have traveled in this country in race relations in the last 160 years. This decision pitted two men against one another. Both men had much in common. They each had a wife and two daughters who they loved very much. One was a slave, Dred Scott, and the other was Chief Justice Roger B. Taney. He was Justice of the Supreme Court. While Dred Scott was tenacious in securing freedom for himself and his family, Judge Taney was equally committed to denying Dred Scott his freedom. While I am sure Dred Scott would have no problem acknowledging the humanity of Chief Justice Taney, Chief Justice Taney could not acknowledge the humanity of Dred Scott, as we shall see. This is one of two pictures we have of Dred Scott. How can anyone look at his face and deny his humanity? The essential facts of this case are simple. Dred Scott's owner was Dr. John Emerson, who served in the Army and took Dred Scott to Illinois, where he was the doctor's personal servant from 1838 to 1841. Then in 1841, Dr. Emerson transferred to the Wisconsin Territory and took Dred Scott with him. Both Illinois and the Wisconsin Territory were free territories that did not permit slavery. While in the Wisconsin Territory, Dred Scott met and married Harriet Robinson. In 1842, Dr. Emerson returned to Missouri, a slave state, and in 1843, Dr. Emerson died, and Dr. Emerson's wife and a man named John Sanford became Dred Scott's owners. The case was brought before the Missouri State Court in 1846, and in 1850, a Missouri jury, in looking at Dred Scott's case, had determined that once free, always free. But the Supreme Court would eventually reverse that, ruling in 1857 essentially that once a slave, always a slave. By the time this case had gone up through state courts and then to the federal courts and finally the United States Supreme Court, 11 years had passed. When this case came before the Supreme Court in 1857, the court decided to address two central questions. The first was, did a black man have the right to appear in court seeking relief? In other words, did he have political standing? Was he a citizen? The second question was equally significant. Was the Missouri Compromise, which limited slavery to territories south of the 3630 line, constitutional? Here is what Judge Taney said to the first question, quote, "The African race in the United States, even when free, are everywhere a degraded class. The privileges they are allowed to enjoy are accorded to them as a matter of kindness and benevolence rather than right. They were not looked upon as citizens by the contracting parties who formed the Constitution." Now, the contracting parties that Judge Taney refers to here were the states, and Judge Taney had to ignore the fact that free blacks were considered citizens by many states when the Constitution was adopted. To cover this problem, Taney looked outside the United States for support and cited the state of public opinion in England and in Europe at the time of the Constitution's ratification. Taney ruled that blacks were regarded as beings of an inferior order, and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights that the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his own benefit. Judge Taney depicted the treatment of blacks in cold, harsh words. He said about the black that he was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. Of course, he was talking about the black slaves at the time. And he went on and he said this opinion is fixed and universal in the civilized portion of the white race. Well, Judge Taney was wrong about the status of blacks in the northern colonies at the time of the Constitution's ratification, but was he correct in his comment about the civilized portion of the white race? William Blackstone's commentaries on the laws of England was a reflection of English common law in 1765. And his commentaries stated this, quote, "A slave or Negro, the instant he lands in England, becomes a free man with all the rights of English citizenship." Judge Taney was completely wrong about what the civilized portion of the white race believed. For nearly a century in England, blacks had the same rights that whites had. Judge Taney was wrong about the citizenship of blacks in the early colonies, and he was wrong about the citizenship of blacks in England. In the Lincoln-Douglas debates, the next year in 1858, you can appreciate how Abraham Lincoln spent over half of his debate time tearing apart the Dred Scott decision for exactly these kinds of errors. While this portion of the opinion enraged many in the North, it was the second part of the Dred Scott decision which drew the most condemnation. Do you remember the issue? It was this. Was the Missouri Compromise, which limited slavery to the territories south of the 3630 line, constitutional? From our nation's founding, slavery was always a source of tension, and as with all issues we did not agree on, compromise had been our salvation. The Missouri Compromise, which limited slavery to territories south of the 3630 line, had been an important compromise to avoid the nation being torn apart. With the Dred Scott decision, all that changed. In the map behind me, the pink states were free states, California becoming a free state in 1850. The green states were slave states, and the yellow states were territories open to slavery because of this decision. If Judge Taney had had his way, about 75% of our nation would be forced to embrace slavery, something completely unacceptable to Northerners. One of the great ironies of the Dred Scott decision is that Southerners who talked a lot about states' rights and local control really had no problem in using this decision to force slavery down the throats of people in the territories opposed to slavery, even if it was a clear majority who opposed slavery. Only 4 years passed between the Dred Scott decision and the outbreak of the Civil War. During that time, a firestorm of protest against the Supreme Court and President James Buchanan, who supported the decision, was unleashed in the North. In his famous House Divided speech, Abraham Lincoln summed it all up in these prophetic words, quote, "A house divided against itself cannot stand. I believe this government cannot endure permanently, half slave and half free. I do not expect the Union to be dissolved. I do not expect the House to fall. But I do expect it will cease to be divided. It will become all one thing or all the other. Either the opponents of slavery will arrest the further spread of it and place it where the public mind shall rest in the belief that it is in the course of ultimate extinction, or its advocates will push it forward till it shall become lawful in all the states, old as well as new, north as well as south." Close quote. The Dred Scott decision shook many otherwise apathetic Northerners. They realized for the first time that a nation could arise where the institution of slavery from coast to coast and north to south was a reality. When Abraham Lincoln was inaugurated March 4th, 1861, his foil in his debates had been Chief Justice Roger B. Taney and the Dred Scott decision. Who administers the oath of office to the incoming president? If you said the Chief Justice of the United States, you would be correct. And who was the Chief Justice? Give me a drum roll. Roger B. Taney. I cannot help but suspect that March 4th, 1861 was one of the saddest days of Justice Taney's life, as he administered the oath of office to Abraham Lincoln, the Illinois lawyer who became president largely because of his brilliant attacks upon the Dred Scott decision. Judge Taney died a month before Lincoln's election 4 years later, sparing him a second humiliation. Shortly after the war, the Dred Scott decision was thrown into the ash heap of history and totally repudiated by the 13th Amendment, an amendment written with the tears, sweat, and blood of that generation and guided to passage by the steady hand of Abraham Lincoln. The 13th Amendment states as follows, quote, "Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction." While the Dred Scott decision was a terrible decision in American history, we can take pride in the fact that we did not simply accept that decision. That generation of Americans got it right in standing up to evil and in amending our Constitution to right some terrible wrongs. No generation before or since endured as much sacrifice in crafting what this nation has become. Their determination was truly extraordinary. Who were the players in this drama? First and foremost was a black man born into slavery, whose courage and tenacity caused America to confront slavery. Without the leadership and determination of a man born into the grinding poverty of the backwoods of Kentucky, who rose to the presidency, the 13th Amendment could never have passed. Yet Abraham Lincoln would be the first to remind us that the 13th Amendment would not have been possible were it not for the millions of Union soldiers who fought in this terrible war for Union. These are only a few of those men. Look in their faces and see the humanity in them, as you did Dred Scott. As I have said many times before, the Dred Scott decision and the antidote in the 13th Amendment is an amazing story, but it is not a story about extraordinary people, but a story about ordinary people who did extraordinary things.